if the suggestion is that in acting as an attorney, Rodwell and Barrow and Williams did anything in the least bit improper, how is it that the court in Maryland, which was the one hearing the actual complaints, the case against AIBL and the other defendants, how is it that that court appointed a receiver to take charge of Sanctuary Bay and its assets in Belize, and that that receiver, with the approval of the court, retained the self-same Barrow and Williams to act on behalf of the receiver, who is in turn acting on behalf of the victims? It does make sense. If Barrow and Williams had done anything the slightest bit irregular or improper, there is no way they would have become the court, in effect the court-appointed lawyers for the victims, for the receiver who, in fact, has custody of this matter on behalf of the victims.
That your partner owns 2 lots at Sanctuary Bay, and
No.
are you not concerned as to what perception that might...
No, I didn't, but I'm not sure what sort of perception that could give rise to. If he bought 2 lots, I hope that's all he did, and that he didn't pay, like the people in the States, for any kind of construction and that sort of thing. But I don't think it is material, and I say that seriously, because I am saying that the firm operating as lawyers must clearly stay on the right side of the rules governing the profession and on the right side of the law. And I repeat, if there had been any irregularity in the representation of Barrow and Williams of the defendant in the defamation suit or in preparing incorporation papers, there is no way the U.S. court in Maryland would have agreed to Barrow and Williams being retained as the lawyers to represent the receiver and the victims of the scam. That's it, punto final.